started the recording too.
Okay, great, thanks.
The broadcast is now starting. All attendees are in listen-only mode.
Hello everyone and welcome to the Students for Liberty e-Leadership Series. My name is Peter Niger and I'm the Internal Operations Manager for SFL. We're honored today to have Dr. John Hasnas deliver a talk tonight on the failure of the market failure argument. But before we begin though, I'd like to take a moment to introduce Students for Liberty and the e-Leadership program for anyone that's unfamiliar. Students for Liberty is a 501c3 nonprofit organization that is run for students and by students that are dedicated to liberty. We were formed about 2 years ago to serve a niche at our universities by connecting liberty-minded students with other students, faculty, organizations, and resources to help them advance their ideas. These resources include free books for student groups, a speakers network, protest grants, handbooks on running student organizations, tabling kits, leadership training, and an academic journal, and of course, our regional and international conferences. Now, the e-Leadership program is our way of giving you access to the ideas and mentorship in Liberty year-round from wherever you are. We hold 4 webinars per month, 2 on the ideas behind Liberty, and 2 on mentorship and effective techniques in advocating Liberty. All lectures take place at 8 p.m. on Monday nights, Eastern Standard Time, from your computer. For a full list, please visit the website at studentsforliberty.org. Now, I am pleased to introduce our speaker this evening. John Hasnas is an Associate Professor of Business at Georgetown's McDonough School of Business and a Visiting Associate Professor of Law at Georgetown University Law Center here in Washington, D.C., where he teaches courses in ethics and law. Professor Hasnas has also held teaching and fellowship positions in schools of law at Duke University, George Mason, American, and Temple University. And he has also been a visiting scholar at the Kennedy Institute of Ethics in Washington, D.C., and the Social Philosophy and Policy Center in Bowling Green, Ohio. Between 1997 and 1999, Professor Hasnas served as the Assistant General Counsel to Koch Industries in Wichita, Kansas. His scholarship concerns ethics and white-collar crime, jurisprudence, and legal history. His book, Trapped, When Acting Ethically is Against the Law, is now available from the Cato Institute. Now, without further ado, I present to you Dr. John Hasnas.
Thank you very much. Thanks for inviting me to speak tonight. I have to open up with 2 apologies. One is my voice. I have a bit of a cold. I may stop every once in a while. Because of that, hopefully what I have to say will come through clearly. The second apology is I'm not that technologically astute, and I lost the PowerPoint I had for this, but I was able to find another PowerPoint that's for a related talk that has some of the same slides. So, for instance, the slide that's up right now has the wrong title. Just disregard that. I will make do with this older PowerPoint. All right, tonight what I'm going to talk to you about is what I call the failure of the market failure argument. The market failure argument is what I think is a fairly familiar, conventional, academic argument for regulating the market by legislation. I'll describe this to you first, and I will hope that it sounds familiar. The argument goes something like this. It describes the market as the realm of unregulated voluntary transactions. And market forces often have very good results. When 2 parties can trade with each other, often both gain. That's what gains from trade are all about. Each party gains something that he or she wants more than what he or she gives up. Both parties are made better off, and that's why market forces can increase the prosperity of society as a whole. But there are some cases in which when 2 parties engage in trade, each of them is made better off, but their actions have consequences on third parties, those who are not part of the contract. And sometimes the consequences on third parties are negative. So although both parties to the trade are made better off, the side effects of their trade may impose harm on others that are not taken into account by the people actually making the contract. And so in the market, in the realm of unregulated voluntary transactions, these transactions can often impose harm on the community as a whole. The economists will refer to these as negative externalities or negative side effects. These kind of costs are also referred to as social costs, the social costs of private transaction. And the examples of negative externalities are things like pollution or the creation of unsafe products which impose harm on parties. An example might be a car that's satisfactory to the driver and nevertheless poses risks to pedestrians. Negative externalities don't have to be so concrete in form. They can be cultural degradation. I believe the French think that having McDonald's all over the place actually poses harm on their society in a cultural way. At any rate, the negative externalities or the harmful effects on third parties who are not taken into account by the contracting parties constitute the social cost of these private transactions. And in cases in which the social costs are greater than the gains that the private parties get from making the contract, society as a whole doesn't prosper but actually suffers a detriment. And this is supposed to be an example of where the market fails. The market fails to deliver a beneficial social outcome. And the claim is that in cases like this, in the cases in which the social cost of private transactions outweigh the gains to the contracting parties, there's a need for something to come in and correct the market failure. And what comes in and does this is the law. The law is described in this model as the regulation of voluntary transactions for the public good. The legislation is depicted as something that's designed to internalize negative externalities and to privatize the social costs of market transactions. Legislation in this model is offered as the remedy for market failure. I hope that this seems like a familiar or an accurate description of the kind of argument that I believe is frequently made to justify legislative intervention into the market. I will put it up on the screen, I hope. Excuse me for a moment.
Dr. Hasnas?
Yeah.
I hate to interrupt, but we actually can't. There we go. Now we can see it. Thank
Okay.
you very much.
Okay, I seem to have successfully put up on the screen a picture, and this picture depicts what I regard as the relationship between the law and the market in the model I just described. I've called it the academic conception. In this academic conception, the market is the realm of unregulated voluntary transactions. Law is the regulation of voluntary transactions for the public good. Separate. So law is a regulatory realm that is entirely separate from the market. If this seems familiar to you, or if you don't think I've misdescribed things, then here is the most frequently offered justification for government interference. Now, I am not trained as an economist. My training is in law and philosophy. And in fact, I didn't encounter the market failure argument until after I had already graduated from law school. I didn't take much economics myself. I didn't get this argument presented to me in college, like many of you have. And perhaps that's why this argument has always sounded very silly, if not patently absurd to me. Because I was trained as an attorney, this seems ridiculous. It seems to be so out of touch with reality that only people with PhDs could actually believe it. And the reason why I say that is because, in my opinion, it completely mischaracterizes both the law and the market. So let me start by describing the law first. Law is a generic term that encompasses, at least in our system, two very different types of things. In our system, in the Anglo-American common law legal system, there are actually two forms of law. There's common law and there's statutory law. Statutory law is familiar to most of us. Statutory law is legislation. It's the law that's created by the actions of elected representatives. In contrast, common law is case-generated law. It's law that arises from the settlement of actual disputes. We're all very familiar with statutory law because we're raised to understand law, statutory law. When I give this talk to a live audience who's sitting there who I can see, I usually bring up something that strikes a chord of recognition, which is almost all of the students who go to school or public school in the United States are what I call dancing bill people. And what that means is when you were very young in elementary school, you were shown a little video of a bill that sings and dances its way through the House of Representatives and the Senate. It's got a song, "I'm Just a Bill," and he gets stuck in committee and he's sad, and eventually the president signs him and he's a law and now he's happy. And that's the model of law that is presented to people in the United States. That is the model of statutory law. That's how legislation is made. But that represents only one part of our law. The other part of our law is the common law. And as a matter of fact, the bulk of the law that forms the superstructure of our commercial society is not statutory law, but is common law. Common law constitutes property law. It constitutes contract law. All of commercial law arose through common law processes. Tort law is common law. I'll be talking about tort law tonight. Tort law is the law that settles disputes when one party's actions harm another. It's personal injury law. Now, statutory law or legislation can supplant the common law. And much of our common law has been codified so that the common law of contract is now codified in the Uniform Commercial Code. But when that's done, the legislation merely ratifies the results of the common law process. Most of the law that allows us to function in society and to cooperate is not legislation, but is common law that evolved over several centuries. Now, I teach torts. If one party acts in a way that imposes unconsented to harm on a third party, then the injured party may bring a tort suit to recover damages or to obtain an injunction to prevent the harmful activity, or both. The rules of tort law were not enacted by legislatures. They evolved from the needs of ordinary people to live together in peace. There's a lot of ways of illustrating this, but in order to avoid going on at great length, an example I often use is the torts of assault and battery. When I teach tort law, two of the earliest torts we talk about are assault and battery. And in our system, a battery is a harmful or offensive contact. Assault is an action that puts another person in fear or apprehension that he's about to be battered, that he's about to receive a harmful or an offensive contact. And often I'll ask my students to explain why those are the definitions of assault and battery. And invariably they cannot. Of course, striking someone, punching someone would constitute a battery, but a battery is defined as a harmful or offensive contact. A light touch accompanied by a derogatory comment can constitute a battery. Meanwhile, for assault, any offer to strike another party constitutes an assault, but should I swing a baseball bat at somebody's head when that person's back is turned and he or she is unaware of my efforts to batter him or her, then there's no assault, because assault requires awareness. So how can you account for this? It's certainly not designed to discourage immoral behavior, because it's immoral for me to try to hit someone and miss just as much as it is for me to actually hit someone. And battery includes more than just harm. It includes offensive contact. Why are the rules the way they are? And the explanation is historical. The rules evolve over the course of many years, actually over the course of centuries. At the time these rules were evolving, the most urgent need of people in society was to reduce interpersonal violence, and the rules that evolved were designed to do that. Consider battery. If I strike someone, if I make a harmful contact with someone else, how is that person likely to react? And the answer is with violence. On the other hand, if I have a light tap on someone in an offensive manner and make derogatory comments about his ancestry, how's that person likely to react? And the answer is violently. Insult is just as likely to give rise to violence as physical aggression. And so both insulting contact and harmful contact constituted the kind of behavior that needed suppression if you wanted to reduce the level of violence. Then consider assault. Trying to harm someone or trying to make an offensive contact is just as likely to produce a violent response as actually making contact. Swinging at somebody and missing will still provoke a violent response. So assault needed to be discouraged as well. But if you do something that threatens harm to another person and the person's unaware of it, there's no chance of there being a violent response. And if the person finds out later, there's still plenty of time for that person to get help or to deal with it in another way. So the law of assault and battery evolved through a common law process of historical evolution to address the needs of people in society to discourage violence. And the rules are actually very well fitted to that end. Tort law is the law that allows us to settle disputes that come up in society between each other without the resort to violence, and the rules that evolved over the course of time. Today, you may sue other people for negligence, for trespass, for nuisance, for defamation, for any of the harms that one party can do to the other. And that's a description of the way the common law functions. Okay, legislation is the other part of our law. Legislation is not common law. Legislation consists of general rules created by political representatives that apply to all citizens in a jurisdiction. I know that according to democratic theory, legislators represent the will of the public, and they will enact measures designed to achieve the common good. And you're welcome to believe that. But in the real world of politics, very few people see that democratic theory play out. Right? Most people can recognize that political representatives are responsive to political interests and not the general interests. Each time I give a talk like this, I have a different example. But most of us have watched the way the health care bill was debated and passed over the course of the last couple of years. And that should be enough evidence that what is driving the process is not a selfless concern with the public good, but the political interests that are at work behind the scenes. For those of you that study public choice economics, you know that you study this as a discipline, the ways in which private interests can skew legislation away from the theoretical ideal and to benefit private parties. This is what rent-seeking is all about. I don't want to spend a lot of time going over public choice economics, so the illustration I use for the nature of legislation comes from an interview that was given by George Mitchell when he left the Senate in 1994. George Mitchell was then the Senate Majority Leader, and he left the Senate with the highest reputation for integrity that anyone anyone in the Senate had ever had. His reputation for integrity was so high that the Major League Baseball tried to hire him as commissioner, but instead he went to Northern Ireland and helped negotiate peace there, and I believe that right now his current role is to help negotiate peace in the Middle East. He's a man whose integrity is respected across the world. When he was retiring from the Senate, he gave an interview to National Public Radio, And in the course of the interview, the woman who was interviewing him asked him, said to him, Senator Mitchell, being the Senate Majority Leader is a tough job. You have to deal with all these personalities. You have all of the hassles of dealing with the opposition. There's long hours. I mean, what makes all of this worth it to you? And he gave a very honest answer to this. He said he told a little story. And the story he gave was as follows. Senator Mitchell was the senator from Maine. Maine manufactures paper. There's a lot of paper mills up there. The Clinton administration had a proposed policy to require the entire federal government to use only recycled paper products. And apparently the Clinton administration thought that that would be good for society as a whole. But George Mitchell realized that if that measure had been adopted, it would have bad consequences in his home state because there would be less paper purchased and it could mean that people in his state would lose jobs. And he explained that as the Senate Majority Leader, he had a position of power which enabled him to prevent that measure from being adopted. And he told a story about when he was home in Maine, he was giving a speech somewhere, and after the speech, a man came rushing up to him, and at first he and his bodyguards thought it was somebody who was going to attack him, but they found that wasn't the case. It was someone who was just very emotional. He came up, and he had tears in his eyes, and he was thanking George Mitchell for saving his job. He was somebody who worked in a paper mill. And as George Mitchell said in the interview, and it's that kind of thing that makes all the long hours and the hard work worthwhile. And so what the senator who left the Senate with the highest possible reputation for integrity had just said is that the virtue of having a position of power is that you can use it to thwart the general good and the public interest in order to protect your own parochial special interest. And if George Mitchell tells you that that's what power is for, we have every reason to believe him. Right? That's my argument for the conclusion that legislation is correctly understood not as rules that necessarily serve the public interest, but rather as rules that reflect the politically dominant interest. Excuse me. Okay, that is my account of the law. Our law consists of two parts, common law and legislation. I've described each part. I want to move on now and talk about what the market is. All right, first of all, I'd like to point out that there's no such thing as the realm of unregulated voluntary transactions. I mean, that may be useful to economists if they're engaging in some kind of ideal modeling. The idea of a perfect vacuum is useful to physicists as well. But physicists don't think that there is an ideal vacuum or a perfect vacuum anywhere. And hopefully economists don't think there's any place that actually exists that constitutes a realm of unregulated voluntary transactions. Human activity is always subject to some form of regulation. Our activity is regulated by the ethical beliefs within which we function. Our conduct is regulated by customary practices that everyone accepts and conforms their behavior to. And in our system of law, in the Anglo-American system of law, our behavior is regulated by common law civil liability, by tort law, by contract law, by property law. Well, given that that's the case, given that there is no such thing as the realm of unregulated voluntary transactions, what can the term market refer to in the real world? And I'll make a suggestion. In the real world, if we want to talk about markets, what we must be talking about is the realm of human interaction in the absence of centralized coercive authority. In other words, the market in the real world would be voluntary transactions not subject to political control or regulation. That would mean real-world markets constitute the realm of voluntary transactions that are regulated, but only by ethics, custom, and civil liability. Now, if you followed my description of the law and the market, then I'm ready to propose to you a different model of the relationship between the law and the market. That's this, the one I have up on your screen right now. And what I call the real-world conception, the market is correctly understood as voluntary transactions regulated by customs, ethics, and the common law. Law is understood as legislation, which is the regulation of voluntary transactions by the state to serve the politically dominant interest, and also the common law. And these are not separate realms. They overlap. And the place where they overlap is the common law, because the common law is part of the market realm as well. So if you will, the common law is the market's internal regulatory mechanism. In a sense, regulation of human conduct is, I'll use economic terminology, is endogenous to the market. Given that this is what I believe to be the real-world relationship between law and the market, I'll ask you to reconsider the market failure argument. Right. Notice that civil liability constitutes the market's internal regulatory mechanism. Right. One question we can ask is, how effective is that regulatory mechanism? Well, about 10 years ago, Ed Rendell, who's currently the governor of Pennsylvania, was the Democratic National Committee chairman, and he was addressing a convention, a conference of trial lawyers, actually trying to get them to donate to the Democratic Party. And in addressing them, he inadvertently told the truth in public, which was as follows. He said that trial lawyers paved the way for America's consumer safety advances, and, quote, 80 to 90% of those safety advances came from litigation. And what he was pointing out was most of the safety regulation that preserves us and that keeps us safe doesn't come from legislation. It comes from litigation. It comes from common law. It comes from civil liability. People are mostly unfamiliar with tort law. If they've heard of anything having to do with tort law, it's almost certainly the McDonald's coffee cup case. The story about the woman who opened up a cup of coffee between her legs, spilled it on herself, and collected millions of dollars. Well, the McDonald's coffee cup case is perhaps a wonderful illustration of the way the common law functions as a regulatory mechanism. The real facts behind that case are that McDonald's had been serving coffee in its restaurants at a temperature of 185 degrees Fahrenheit. At that temperature, coffee will cause third-degree burns on a human being in between 2 and 7 seconds. That's too fast for someone to remove clothing that spills on or to wipe it off. McDonald's was aware of the danger of serving coffee at this temperature because they've had over 700 complaints in the past. It's not, people don't only spill coffee on themselves. McDonald's employees sometimes spill coffee on other people, and people have been injured. McDonald's had settled several lawsuits and was aware of the danger. It's also the case that at 157 degrees Fahrenheit, it takes up to 30 seconds to cause third-degree burns, which is enough time to get the coffee off you before you're seriously injured. And 157 degrees Fahrenheit is still too hot for human beings to drink coffee. In the actual case, someone came up to a drive-in window at McDonald's. A son was driving his mother somewhere. He purchased a cup of coffee, handed it to his mother. She opened it between her legs. She got third-degree burns. They sued McDonald's. The jury was made aware of McDonald's behavior, and they found in favor of the plaintiff. They awarded punitive damages equal to 2 days' worth of profit that McDonald's makes on coffee, which was $2.9 million. And then they reduced the judgment by 30% because of the woman's own negligence in the way she opened it. The next day, every fast food restaurant in the United States served coffee at 157 degrees Fahrenheit. One tort decision had made every single person in the United States safe from third-degree burns from coffee spills overnight. You may argue back and forth about whether this is a good decision or not, but what you can't argue about is whether or not tort civil liability is effective safety regulation. That's effective regulation. Imagine what would have been the case if we asked a government regulatory agency to establish a safe temperature for coffee in restaurants across the United States. The debate would go on for months. There would be lobbying on either side, and eventually they'd set the temperature at something like 175 degrees, somewhere in the middle, in a way that's not scientifically based. Civil liability and tort law may be too regulatory, but there's really not an argument available that it's not regulatory enough. The presence, the existence of the tort reform movement is evidence of that. If businesses are spending a lot of time lobbying their state legislatures and the Congress people in Washington to get relief from tort liability, then that's the strongest evidence I can offer that tort liability is an effective regulatory force. There's lots of reasons why business hates tort law. Big business can always influence government regulation. You can capture the regulatory agency, but you can't capture plaintiffs' lawyers. There's an army of them out there. They're turning over every rock looking for anything that might be dangerous. Unlike state agencies, they don't have a limited budget. There's no public choice problems. You can't capture them. What are businesses more afraid of? A small fine that can come from a regulatory agency, or a massive judgment that can come from a tort suit. And just one other story that perhaps illustrates the regulatory force of tort law. There's another story in NPR once a few years ago about an immigrant from Jamaica who was a physician in his home country, and he'd come to the United States, and it was taking him more than a year to get his license here to practice medicine, and he needed a job while he was getting it. And he got this interesting job in New York City. Every week he had to walk a certain section of the city on the sidewalks, looking down and noting all places in which the sidewalk would be dangerous to pedestrians. There was an uneven pavement, there was a hole, something like that, and he would mark this on a map. At the end of the week he would mail in his map, and then he would do the same thing next week, and he was paid a salary for doing this. Was he mailing his maps to the city of New York so that they could come fix the sidewalks? No. He was paid to do this by a plaintiff's attorney who had many people doing it, compiled a map of the sidewalks of the entire city, sent it to the government every week to make sure the government was on notice where there were dangerous portions of the sidewalk, so that if anybody should be injured as a result, he could sue not just for compensatory damages, but prove that the city was on notice and that it was liable. That may be too much regulation, but there's no argument to say that it's not regulatory enough. The last point on this is I will ask you to compare the relative effectiveness of legislative and common law approaches to regulation. So let me see. On your screen now, I've got some steps in the legislative regulatory process. This is what you would do if you wanted to regulate some part of the market for safety through the governmental process. You propose a bill, you deal with the proponents and opponents that are lobbying for its passage, you set up your agency, you begin the regulatory rulemaking process, you deal with the lobbying of the regulated parties, you have to promulgate your rules, publish the rules, create an enforcement mechanism, and then monitor the environment to determine whether changing conditions require revisions of the rules. The alternative way of providing safety regulation is the common law regulatory process, and that's captured in the next slide. That's this. The basic rule of tort law is that every citizen has to exercise the degree of care that a reasonable person would use to avoid causing harm to others by his or her actions. And that system of regulation has been in effect for hundreds of years and is still in effect right now. If the problem with the current tort system is that it is too highly regulative, if the tort reform people are right, that it's too effective at internalizing social costs, then the market failure argument must be unsound. If the regulatory mechanism built into the market, which is common law civil liability, is too highly regulative, then it clearly makes no sense to say that in the absence of legislation, there would be uninternalized negative externalities or social costs that are not taken into account. So the conventional market failure argument isn't just wrong, it seems to be obviously wrong. It only makes sense if you completely ignore the existence of tort law and you refuse to see the reality that's right in front of your face. Now, having said all this, I should say that there's a way of making the market failure argument make sense. It could be revised. And if it was revised, it would go like this. If there are negative externalities or social costs that are not effectively internalized by the common law civil liability system, then legislative regulation might be justified. A reasonable market failure argument would be if there are negative externalities or social costs in the real world market, which means things that are not dealt with by ethical beliefs, customary practices, and civil liability. If there are still negative externalities that exist and that escape regulation in the real market, then maybe you've got an argument to say that you need an outside force or a legislative body to come in and deal with that. But there's going to be very, very many less examples of that than are traditionally offered. In fact, the challenge I'll give to any of you is, can you identify any negative externalities or social costs that meet this criterion that can't be reached through civil liability and through the common law tort system? Only then do you have a situation in which the market failure argument may be usefully employed. All right, my voice is probably at its limit, so let me stop there and say that completes my argument that the market failure argument itself fails. That's the end.
Okay, do we have any questions for Dr. Hasnas? All right, we've got some questions coming in right now.
Okay.
Well, our first thing is just a comment from Anna. She says, economists don't think about markets as unregulated transactions. No transaction is possible without property rights. People would just steal from one another.
Okay.
Any other questions and answers from the audience? Okay, Logan wants to know what about systemic market failures like the financial markets?
Okay. I'm not sure I'm the right person to address this. What exactly does systemic market failure mean? I mean, I can speculate on things like the financial system and other things, but what you'll be getting from me is speculation on economic matters from someone who's not an economist. Now, I have an opinion on the current financial crisis. It's not directly relevant to my talk tonight. However, I did spend the last 20 to 30 years watching not markets, but government policy distort a particular market. In fact, an interesting little story is there's an individual named Tom Palmer who's associated with the Cato Institute. And in the mid-1990s, he came and gave a talk here at Georgetown to the undergraduates. And during that talk, he pointed out that if government policy with regard to home ownership and mortgages continues the way it's going, what he said was that there'll be a major economic crisis by 2006. Now, he was clearly way off base because it didn't take place until 2008. But over the course of my lifetime, I've watched the government continually subsidize home ownership and have a policy of making home ownership more and more affordable independently of whether people can afford a mortgage. Because it's difficult to afford a mortgage, we had the government subsidize it. We passed all kinds of laws that made it easier. If you distort a market for 30 years, I believe that it's not unreasonable to think there'll be a systemic market failure. But this is not related to the talk I gave tonight, because the talk I gave tonight was in opposition to the justification for regulating the real market. The justification for regulating the real market is the real market will fail to deliver beneficial outcomes because of negative externalities and social costs. That's a reasonable argument only if you're talking about the market in the real world, and in our world, that market comes with built-in regulatory mechanisms that the people who argue for legislative intervention ignore, and that's tort law.
Okay, the next question comes from Alexander. How has globalization during the 20th and now 21st century affected the interpretation of law in terms of commerce law?
I'm not sure I can answer that directly, but I have. Globalization is a great thing. It's a great thing because it allows us to circumvent the law. Now, what I mean by that is the following. For at least 15 years now, globalization's been a big buzzword. And what globalization refers to is the fact that business is being transacted across national boundaries. Notice that there are no world courts, there are no world police forces, there's no world contract law. How is this possible? How can there be international private business transactions without governmental regulatory agencies? The fact that nobody ever talks about this is interesting, because to be news, to be reported on, to be noticed, you need strife. Things have to be going wrong. But we've been conducting business, private business internationally for so long without any war, strife, dissension, that after a while we don't even notice it. What private parties do is they create dispute settlement mechanisms that are efficient, that are convenient, that work for them. As a matter of fact, most people who transact international business don't necessarily go to arbitration. There's a court in Great Britain, the Commercial Court of London, that has the reputation of providing expertise, commercial jurisprudence, and hearing cases quickly. Parties in different countries simply write into their contract that should they encounter difficulty and have a dispute, they'll bring it to the Commercial Court in London. The Commercial Court in London is willing to provide its service for a fee, and things are taken care of in that way, in many ways. All around the world, people are settling disputes in the most effective, convenient way, in ways that work for them, that they come to by agreement. It's the most wonderful example of the way people can regulate themselves independently of any overarching coercive agency.
Okay, Jonathan asked the next question. It says, common law regulation as you presented it makes sense, but wouldn't implementing such a measure require a great behavioral change in the population at large, at least the least of which reversing their government reliance? How do we go about that change, and what do we do in the interim?
Almost always when I get questions about, practical questions about how to do something, I'm not very helpful. In this case, I may be able to be helpful. It's actually very easy. If legislative regulation disappeared tomorrow, there would be no problem. People don't have to change their behavior. Right now, the way people behave is when other people do something that harms them, they get upset and they want recompense. And the criticism not on the United States these days is, oh, we're such a litigious society. People will have no trouble. They don't have to change their behavior. They'll have no trouble using the common law system. Most people who are subject to governmental regulation don't really like it. It's maybe difficult to see how we would get rid of our dependence on all kinds of things the government provide us. But getting rid of legislative regulation of private conduct is no problem, because as soon as it disappears, the other kind of regulation that already exists is there. The only difference between governmental regulation and common law regulation is in common law regulation you have to have a victim. You have to have a harm. The government can regulate anything we do. The government can say you can't smoke cigarettes. The government can say you can't use certain kinds of alcohol or drugs, even though there's no victim. In a common law system, there has to be a harm to a third party before there's a suit. So you get regulation, but you get the kind of regulation that doesn't infringe upon freedom. If the government regulatory system disappeared tomorrow, people would do just fine.
I know you said that specific examples aren't your strongest suit, but we actually have a lot of questions about air pollution and global warming. So if you have any insight into that, it'd be great to hear on how common law would deal with it.
Well, the air pollution and global warming are good examples, because at the end I said, can the market failure argument ever make sense? The answer is, if there are negative externalities that are not internalized, that can't be internalized by the common law system as it exists today, that's when you have a reasonable argument to say that you can, that it might be justification for legislative regulation. So global warming and maybe air pollution are examples that move in that direction. So one possible answer is, all right, those are the ones where the market failure argument may have some effect. Now, do I believe that in myself? The answer is no. To say why the answer is no, I have to talk about another feature of common law that I didn't mention in my talk. Let me see if I can do that briefly. Common law is not just a regulatory mechanism. Common law is also a learning system. It's how human beings learn to solve problems. When conflicts arise, if there's already a rule that governs them, everything's fine. But when you get a conflict over something and it hasn't come up before and it's new and there's a new kind of harm, people try to resolve it in various ways. And the resolutions that are tried are either effective or they aren't. When they're not effective, then the problem comes up again and people have to try to solve it again, and they try something else. When there's an effective resolution that comes up, people quickly learn that that works, they all copy it, and now that problem is solved, and you move on to the next. The common law is an evolving learning system by which human beings solve new problems, and the old problems fade away because they've been resolved. When I teach torts, my students are often amused by so many of the cases are railroad cases. But that's because in the 19th century, railroad was the new technology, and people didn't know how to use railroads safely, and they needed cases and trial and error to find out what the proper rules were. Now, there's no railroad cases never come up because we have the rules. But today, the issues are other things, like how to use the internet, or the kind of danger that comes from chemicals, or things that are small pollutants. What's the best way of providing safety in these circumstances? We don't know, but we learn. In the old days, a trespass was physically coming onto somebody's property. But when we got into more modern times where plants were putting up soot and particles, the question arose as to whether these fine invisible particles coming on somebody's land could give rise to an action. Some people said no, some people said yes. But the way the common law resolved it was to say, yes, if there are particles that enter onto your land, these pollutants, then that's a trespass or a nuisance, and you can sue. It was actually a slightly different rule than the old rule, but the common law evolved to address these new problems. Air pollution that causes harm to individuals is not really that much of a problem. If there's measurable harm and you can show that it comes from a pollutant, you don't even have to identify the particular polluter to bring a lawsuit because, excuse me, something else that developed recently through common law evolutionary process is called enterprise liability. And if you know that there's a certain number of people who manufacture our products or engage in an activity, and you can combine many of these actors into one lawsuit, you can sue them and force them to show that they are not the person causing the harm and collect damages that are proportional to their market share of whatever the pollutant, whatever the item is. It's called enterprise liability. The common law constantly evolves to solve new problems. It's how we learn to deal with these things. And it tends to give better results than getting a bunch of politically motivated politicians together and saying, here, give us some rules. And politicians are almost always either captured by the industry that's supposed to regulate or by activist groups, and you get rules that serve a political interest rather than address the problem itself. So the fact that there are questions I can't answer now does not lead me to question my faith in common law being a good regulatory system. It just means there are new problems that we have to learn how to answer. That's no answer for global warming. All I can do for the people interested in global warming is refer you to an article by Jonathan Adler, who's a law professor at Case Western Law School, and he's probably the best writer on environmental matters these days, in which he speculates on ways in which a system like a civil liability system could actually function on a global scale to help internalize the externality associated with global warming. But that's a highly speculative response on his part.
Okay, Edgar asks, is it possible to quantify the common law's effect on internalizing costs?
If it is, I don't know how to do it, and I'm not sure what that means. I don't know what it means by quantifying. The common law resolves problems in which there's a conflict such that one person is motivated to try to get compensation from another. How much compensation, if you're talking about quantification, you're talking about monetary damages, yeah, there's a whole legal science about that. Otherwise, I'm not sure what quantification means. Can we measure how effective it is compared to governmental regulation? Perhaps somebody can. I hope someone does. I mean, when those measures are made, it's always amazing how ineffective the legislative regulation is. And the studies that are actually done of tort law, I mean, most people have no idea how tort law functions because you just hear about the McDonald's coffee cup case, you hear about massive million or billion dollar judgments. These are all aberrations. They're actually never paid, even in the McDonald's case. The $2.9 million judgment was never paid. That ended up to be only $300,000 after this process was over. But when you look at the way it actually works, in reality, it's an amazingly subtle, nuanced system that gives really, really good regulation. And there's all kinds of limits on of what you can recover through tort law that I wouldn't have thought of, legislators wouldn't think of. It evolved because it actually works. I guess I should leave it at that.
Okay, this is unfortunately going to be the last question. This comes from Betty. I understand common law to stem from non-encroachment principles. How can we educate others to think this way? People tend to be afraid to move or even think without specific rules in place.
I'm not sure. A lot of you have terminology that I'm not familiar with. I'm not sure what non-encroachment principles are. So I'll give you a general vague response. I tend to advocate for common law and for a tort system, for a regulatory system based on civil liability, because it gives us rules where we need them, because it provides rules people need to live together in peace, and it doesn't create any other rules. It resolves conflicts, and it does nothing else. It arises from there being a private plaintiff, someone who's harmed, somebody who wants redress. And it teaches us how to make it so that when people act in ways that cause conflict, we have rules that resolve them and reduce the conflict. And it doesn't create rules in any other circumstance. So what you get out of common law is what I will refer to as a highly libertarian type of legal system. There's no mechanism for creating rules that restrict freedom. There's only a mechanism for creating rules that allow people to compose their disputes. And because there's no such thing as the realm of unregulated transactions, because we need regulations in order to live together, the common law gives us a more effective type of regulation than we can ever hope to get out of government, which is inevitably driven by political considerations.
Okay, thank you very much, Dr. Hasnas, and all of our participants this evening. I hope you can all continue coming back to our webinars to learn more throughout the year. Our next webinar is, of course, next Monday, November 15th. Dr. James Lark is joining us for the third installment of his series, and he's going to talk about important issues in interpreting public policy data. To register, please visit our website at studentsforliberty.org. As always, we'll be sending up a follow-up survey soon. Please take a couple of moments to fill it out. It'll allow us to improve the programs for the coming year. And with that, we're officially wrapped up. Thank you again, Dr. Hasnas, and I hope to see you guys next week.
Thank you.